The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The 14th Amendment states, no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Today we're going to be addressing the constitutionality of the death penalty in light of the 8th and 14th Amendments. 5 landmark cases were decided on July 2nd, 1976, and therefore are commonly known as the July 2nd or the death penalty cases. Gregg versus Georgia is the main case that I'll focus on with you today, but I will also briefly explain the cases of Roberts versus Louisiana, Woodson versus North Carolina, Jurek versus Texas, and Prophet versus Florida. Prior to coming to any conclusions about the death penalty, we must first ask ourselves what the objective is behind the death penalty. The objective, to my knowledge, is twofold: retribution for a heinous act and general deterrence to keep the population from committing this crime in the future. To give you a little background, in 1972, the landmark case of Furman versus Georgia addressed the death penalty and set precedent prior to these 5 cases being heard. Furman himself was attempting to burglarize a home when the homeowner caught him. Furman had a gun on him, and in his attempt to escape, Furman tripped, and when he fell, the gun he had in his possession fired and killed the homeowner. Furman was sentenced to death after being found guilty of murder, but he and his lawyers argued against the constitutionality of the death penalty. The Supreme Court didn't quite agree with that. They decided that there needed to be requirements for specific guidelines for certain types of crimes that the death penalty could be mandated for. If there were no guidelines for this punishment, then it would be considered to be cruel and unusual and therefore unconstitutional. Many states enacted their own criteria or schemes regarding the de facto death penalty for these crimes, and other states completely did away with the death penalty in response to this decision. Louisiana was one of the states that created a scheme concerning the death penalty based off the Furman versus Georgia case. The scheme called for a mandatory death sentence for certain crimes. The scheme also required the judge to instruct the jury on lesser crimes of manslaughter or second-degree murder, even in the event that there was no evidence to support that the suspect had committed these lesser crimes. In other words, even if all evidence pointed to first-degree murder, the judge was still required to instruct the jury, on these lesser offenses. I believe that the intent of this was possibly to lessen the use of capital punishment. Roberts had been convicted of first-degree murder and sentenced to death in accordance with this very same scheme that Louisiana had enacted. And in 1976, Roberts' lawyers argued to the Supreme Court that the scheme was unconstitutional in that it violated the rights guaranteed to Roberts by the 14th and the 8th Amendments. The lower courts did not agree with this allegation. The Supreme Court, however, decided that by imposing the death sentence on citizens automatically, it did in fact violate the rights afforded by the Constitution. Mandating this penalty did not allow the jury to consider any mitigating circumstances that might arise in the situation. The Supreme Court also found it unconstitutional for the jury to be instructed on lesser charges without evidence being precedent. It made way for the jury to consider a verdict in accordance with a lesser crime than had actually been committed. And in 1893, North Carolina made changes to the then mandatory death sentence for murder. North Carolina redefined murder by dividing it into 2 categories. Prior to Furman versus Georgia, the jury was not allowed the discretion of imposing a death sentence or to life in prison. After Furman versus Georgia, first-degree murder only carried the mandatory death sentence. It remained this way until 1974, when James Woodson appealed his death sentence for first-degree murder to the Supreme Court. Woodson's lawyers believed that the mandatory sentence violated the Eighth Amendment for 3 reasons. The first reason being that most people at the time were opposed to the use of mandatory death sentencing. Secondly, the legislation failed to give the jury the power to determine if the offender should die or not. And thirdly, mitigating circumstances such as the situation and the character of the offender were not taken into account. Much like the last case we talked about, the court felt that the Constitution was based around a fundamental respect for humanity, and Woodson's death sentence was overturned. Now, Jurek versus Texas was a man named Jerry Jurek. He was found guilty of brutally murdering a 10-year-old girl. And at this time, Texas had a mandatory death sentence as long as 3 criteria were met by the crime. In simple terms, were the actions of the offender deliberate with the intent of causing death? Would the offender pose danger of future violence to the public? And lastly, was the actions taken by the defender a reasonable response to provocative actions taken by the individual that had been killed? The jury only considered the first 2 questions due to the fact that the victim was only a 10-year-old girl. Jurek's lawyers appealed to the Supreme Court, arguing that the standards in which Texas courts impose the death penalty and the death penalty itself were both violations of his 8th and 14th Amendment rights. Now, Proffitt versus Florida was another case in which a man had been convicted of first-degree murder and sentenced to death. Now, Proffitt's lawyers also argued that the death penalty was cruel and unusual and therefore unconstitutional. They also did not agree with the fact that the judge was the one who chose a sentence rather than a jury. The Supreme Court did not agree with Proffitt's lawyers' arguments. They found that the death penalty was not unconstitutional and that having a judge decide the sentence did not violate any rights. Now for the lead case of Gregg versus Georgia. A man by the name of Troy Gregg robbed 2 men and killed them. And he dumped their bodies in a ditch, and once the bodies were discovered, the investigation led authorities to Gregg. Gregg claimed that he had acted in self-defense at the time of the murders, and therefore the killings were justified. But the court did not find this to be true, and they convicted him on 2 counts of first-degree murder. And Troy Gregg was sentenced to death for his crimes. The legal question that was brought before the Supreme Court was once again, is the death penalty a violation of a citizen's 8th and 14th Amendment rights? Whether or not Georgia's criteria for death penalty sentencing was in the legal boundary was also brought into question. Gregg's lawyers did not believe that this instance met the requirements that were laid down by the case of Furman versus Georgia. Therefore, the death penalty was unconstitutional and that it violated his 8th Amendment right to be free from cruel and unusual punishment. The lower courts affirmed the original finding and upheld the conviction and sentence. The state of Georgia argued that the system that had been put in place following the Furman versus Georgia case did in fact uphold the Constitution. And they argued that the state had the legal authority to sentence individuals to death based off of the strict criteria that they had put in place. They pointed out that the bifurcated trial and sentencing, or the fact that the trial and sentence was 2 different occasions, removed any sort of capriciousness or arbitration from the procedure. In a 7-2 decision, the Supreme Court reaffirmed the lower court's ruling and declared in an opinion written by Justice Potter Stewart, the death penalty is not considered to be unconstitutional under all circumstances, only some. And these situations in which the death penalty can be employed and is constitutional are those of extreme depravity, such as intentionally killing or maliciously killing another. Justice Powell and Justice Stevens agreed. Justice White also wrote a concurring opinion and was joined by Justice Berger, Justice Rehnquist, and Justice Blackmun. He believed that the lower court's reasonings for upholding the original convictions were sound, and he did not believe that Gregg's argument held any merit whatsoever. Justice Marshall and Justice Brennan both wrote dissenting opinions in which they questioned the morality of a society that can elect to end a life of one of its citizens. They did not believe that the public as a whole would find it acceptable given that they fully understood the ramifications of the death penalty. The decision of these 5 cases, Gregg versus Georgia in particular, have had great impact on the legal system. The outcome of the case finalized the question of constitutionality concerning the death penalty. There were also 3 questions that were to be asked in regard to using the death penalty in future cases. Courts must consider the following: whether the sentence of death was imposed under the influence of passion, prejudice, or any other arbitrary factor; whether in cases other than treason or aircraft hijacking, the evidence supports the jury's or the judge's finding of statutory aggravated circumstance; and 3, whether the sentence of death is excessive or disproportionate to the penalty that is imposed in similar cases, when you consider both the crime and the defendant. Now, this answered the question of the constitutionality, but the debate will still be among the citizens and legislature on whether or not it's constitutional. But I believe that there will always be a debate on this. The moral fabric of our society is ever changing, and with it, our expectations for the judicial system and how it performs its duties. Ironically enough, Troy Gregg escaped from prison the day before he was put to death. However, that evening, he was beat to death in a bar the very same night.